Morning, ladies and gentlemen. To my sheriff colleagues, deputy sheriffs, admin staff, and employees of the board that are attending this morning, thank you very much for making the time and even taking the time to register for this information session that we are going to attend to this morning. Let's start. On behalf of the SA Board for Sheriffs, I would like to welcome every single person that has signed up, registered, and is sitting in front of a screen this morning watching us. It's great to start the year off with the information session. It's been very quiet for a while, so we are very excited to start with this initiative. Today we will be doing the Magistrate Court amendments as recently published. And I truly hope that you will find this informative and helpful. Allow me to introduce my colleagues, the training committee, Mrs. Titus, Amanda Titus, and Pakama Mlandu. Both of those training committee members are present this morning, and they'll be working in the background. And for those who don't know, my name is Ian Burton. I am Sheriff of Palm Ridge, and I'm also the chairperson of the training committee for the SA Board for Sheriffs. In the absence of Mr. Nell, who is still currently traveling back from their trip, I would like to introduce to you the training and communications department staff: Bernadine Dow, Lucinda Delport, Candice George. These are the ladies that will be operating in the engine room this morning, and they will keep this session going. It's their first time ever, so it's quite exciting, and it's I believe it's quite a challenge for them, but I know they are capable, and they were able to do this without hiccups. I would also like to introduce to you the man of the hour, Mr. Ashraf Dawood. He's our board facilitator, and he will be facilitating this information session this morning. Mr. Dawood is a sheriff of Cullinan, and he's also one of the board-approved facilitators. From our side as a training department and the training committee, I just would like to say that it is our wish that this will be the first of many sessions to come this year, and that the info shared will not only empower the sheriffs and the staff with knowledge, but also improve their skills that will lead to the excellent service delivered by their officers. Just one or two formalities this morning. There's a Q&A block at the bottom of your screen in the taskbar. All questions can be posed or typed in the Q&A taskbar. Mrs. Pakama Mlandu will pose those questions to Mr. Dawood when he is ready to take questions, and those questions will then be answered. In the chat box, there is going to appear a register. If you open the chat box in the taskbar, there will be a register that I please ask that you complete, just to say that you are present. And all I can say is let the fun and games begin, Mr. Dawood. Thank you very much for making the time and the preparation for this, and I truly hope that today is going to be a successful and productive one. Thank you very much.
Thank you very much, Mr. Burton, for that warm welcome. Good morning, everybody. Colleagues, it's great to be in your company this morning. As Ian has pointed out, it's a great privilege to have everybody here with us this morning, giving up your time. It's great to be in your company today. We're going to be discussing the amendments to the Magistrates Court rules. Please note that it's important just to note that there's a general consensus that the slides that we're going to present today is an accurate interpretation of the amendments. However, we don't know it all. There are some certain gray areas in these rules. So if you feel that we've misinterpreted any of these rules, please, in the Q&A box, please add your opinion, your interpretation of the rule. After all, we're just here to learn today. All of us are here to learn today. As I stated earlier, this is a discussion, and by no means a final discussion of the amendments to these rules. There are certain gray areas, as I've mentioned before, where we require clarity from the legislators, we've asked the Rules Board for clarity. And as usual, the answers we've received beg more questions than answers, but we will pursue this. Just some of the house rules before we start, colleagues. Please feel free at any time to ask questions by placing it in the Q&A box. That questions will be forwarded to me. And it's quite possible that we won't have all the answers today, but you're most welcome to send the questions in the Q&A with your contact details. And when important that you complete that. Without that, you won't be able to get a certificate of attendance. So please complete that. Remember, ladies and gentlemen, the purpose of today is to share knowledge in order for us to empower each other and ultimately to strengthen the profession. If at any time you feel that there is something that I may not be saying correctly, you just raise your hand or place your question in the Q&A box, and we will take it from there. Thank you very much again for attending. I'm going to start with the slides now. If there are any questions, please, like I said, put it in the Q&A box, and thank you. Once again, thank you for your time, and I hope this will be a fruitful morning for all of us. Thank you very much. Okay, ladies and gentlemen, as I've mentioned earlier to you, we are discussing the amendments of the rules, Magistrates Court rules. These rules were published in Government Gazette number 45605 on the 17th of December 2021, but has already come into effect from the 1st of February 2022. The Government Gazette was emailed to you with the link to today's information session. It's advisable to have the Government Gazette with you right now, as this would make more sense. It would give clarity on what we're going to be discussing. Ladies and gentlemen, I just want to point out that we don't have a lot of time today. It's been scheduled for, I think, for 2 hours. So what we're going to discuss is the amendments to the rules. I'm not going to go through the old rule in detail and then show you what the amendment is. We're going to do it where the emphasis is going to be on the amendments to the rules. So I hope that makes it easier for you. And then also bear in mind, ladies and gentlemen, that you need your Government Gazette with you today. It's also important to have the Government Gazette in your office, and important to have the rule books with you in your offices. The rule books that I'm using are these two over here, the Magistrates Court Act and Small Claims Court Act. These are both JUTA books, not advertising for JUTA, but they are very, very important to use in the office. Without further ado, ladies and gentlemen, we now proceed to the next slide. What type of amendments are made or were made? These are the different types of amendments. We have some cosmetic amendments, which I will discuss just now. And then we have an alignment of Magistrates Court to High Court. The cosmetic amendments that were made, for example, the word he, where he was used all the time, now includes the other gender. But the essence of the rule is not changed. And the other cosmetic change that we have is where execution debtor, for example, now becomes judgment debtor. Further amendments that we have, there's a division into sub-rules. And there are renumbering of the rules. So while the rules remain the same, there are renumberings of these rules. And then, of course, there are new rules and insertions. And how this is shown in your Government Gazette, the new rules are underlined, while the old rules are put into square brackets. Starting off with the first type of amendments, first rules. This is amendments, substitutions of Rule 38 of the rules. Ladies and gentlemen, this is very important to note that these rules have changed the way we do things. Previously, Rule 38 was asked for, I need a locksmith, send me a Rule 38, or this or that, I need a Rule 38. The rule has changed. Rule 38.1, if you remember the old rule, it says when the sheriff is in doubt about the validity of the attachment or contemplated attachment, then he gets security from the party suing out the process. The discretion was left to the sheriff. The sheriff was in doubt. He asked for indemnity for security in terms of Rule 38. The new rule says if there is a claim made by any person to any property seized or about to be seized by the sheriff, then the execution creditor gives the sheriff security to his or her satisfaction to indemnify him or her against any loss or damage by reason of seizure thereof. The sheriff will retain or seize as the case may be and keep the said property. The rule is clear, ladies and gentlemen, colleagues. No more doubt. The word is claim. There is no discretion left. No longer if you are in doubt. If there is a claim, you will now ask for that indemnity, for that security. Please, if there are any questions, ladies and gentlemen, put it in the Q&A box and we will get those questions from you. Thank you. Then we come to Rule 38.2. Rule 38.2 is quite clear, but again, lends itself to a bit of the gray area that I was referring to earlier. Rule 38.2 says exceptions, excuse me, where security may not be asked for. This is not a new rule. These rules are there. It says the summons, if the summons was personally served upon the defendant has delivered a notice of intention to defend, or the notice of attachment has been given to the defendant personally. Those are the areas where exceptions are made, where security may not be asked for. Then you look at my last point, I said insurance requirements. Now, ladies and gentlemen, we've been in touch with Santam because as you are well aware, Santam asks that there has to be an indemnity when there is a rule, when there is an attachment or a removal about to be made. This would cover us for insurance purposes. I've asked Santam, I see the questions, I'm going to come to it now. Ms. Mlando, I see your hand, I'll take your question now. We've asked Santam to clarify what their requirements are in terms of this. We've been informed that Santam is looking at these and they will come back to us with some sort of answer. But for now, I think we're all well aware that the rules of court would trump insurance requirements. Ms. Mlando, I see you.
Good morning, everyone. We just have one question from Mr. Shine, and it reads, please define the claim in terms of Rule 38.1.
Okay, thank you. I see that. A claim would be. I'm sorry.
Second one, we'll have the recordings after this, and I think we'll have a YouTube video as well.
Thank you. Coming to the question of the claim, a claim would be if there is more than one person claiming ownership of the goods, as we would normally have. So if there's a claim on the attachments or the goods removed, I think we're referring to that claim. I hope that answers that question. Ms. Nando, I see there are more questions. If you could give me those, please.
No, it was just the one. The other one, there was a greeting. The other one is requesting, inquiring if this will be available. The recording will be available to everyone at large.
Thank you. That's fine. Thank you very much. Then, if I may move along.
Thank you.
The rules. Then we have division of rules into sub-rules. I'm just going to give you an example. Rule 38.2a is divided into Rule 38.2a1 and 38.2a2, which is further subdivided into 38.2a1, 2a2, AA, and BB. So you can see there's quite a bit of subdivision into the rules. And then we move on to Rule 38.2A1, this is cosmetic change. The word execution debtor becomes judgment debtor. Then we come to 38.2 there. It says, this is important, if security is not given. This obviously refers to when there is a claim. Security is not given. The attachment will automatically be suspended until security is given, provided that AA, the attachment lapses after 4 months from the date of attachment. This is an insertion into the rule. It says the attachment lapses from the date of attachment. Ladies and gentlemen, we're well aware that the life of an attachment in the magistrate's court where there is no matters pending lapses after 4 months. They've included this into the rules now. Then we come to BB, where it says by the execution debtor may by endorsement on the warrant dispense with giving security. If there are no questions, I'm going to go on to the next slide. Rule 38.3, there's no changes. Rule 38.4, merely the words or any person entitled thereto has been added to the rule. Now, like I said, this will make sense to you, ladies and gentlemen, if you have the government gazette with you. Rule 38.5, ladies and gentlemen, very, very important amendment. The rule shall not apply where the party suing out the process is represented by Legal Aid South Africa. Now, what is the amendment to this rule? The previous rule stated that where the minister, the state, the premier, in their professional capacities, they were exempt from supplying the security. This rule is now changed. It says that it will not apply where the party suing out the process is represented by Legal Aid South Africa. Meaning what? Meaning that the minister, the state, premiers in their official capacities, the state attorney would now have to supply the security. That is what it means here. Now, for those of colleagues, I confused this at the beginning as well with myself, where I said represented by legal aid. We mustn't confuse legal aid with legal wise. Legal aid is different from legal wise. Okay. Are there any questions at this point? Nothing. Moving right along. I see Mr. Burton is based. Yes, Mr. Burton.
Sorry to interrupt. There's just a question in the chat group. Hanli Rasmus is asking, what does this suspension entail? Does it mean that the attachment stays in place and keeps counting to the date of lapse, but you refuse to do the removal and sale, or what does it mean?
Okay, if I could, I'm just going back to the slide here now.
Thank you,
are you referring to 38 2A2? Are we referring that if security is not given, the attachment B will be automatically suspended until security is given? Are we referring to that point, Mr.
I take it that's what Hanli was referring to, sir.
If you can just repeat the question, please, sir.
What does this suspension entail? Does it mean that the attachment stays in place and keeps counting to the lapse date, but you refuse to do the removal or the sale? That's the context of her question.
Yeah, so if security is not given, the rule says that the attachment automatically suspended until security is given, provided it lapses after 4 months. Now, again, here, this is that bit of the gray area that we were talking about here. It will be suspended. So the question now is, if I get your question, from when do we start counting? That is one of the questions which we put to the rules board, and we're still awaiting the answer on that. Okay. May I move along? Thank you. Insertions into Rule 39. 39.1, there's no change. Rule 39.2a basically states that the proceeds of goods sold in execution, when we pay this out now, the proceeds, it will be in order of preference referred to in terms of Rule 43.1.14c. Basically, it states that how this is done. The preference creditor is then paid out in terms of his status, And then the other creditors are paid out as per the Insolvency Act. You can check this in your rule books. It will give you a nice outline of what is referred to there. Rule 39.3, Rule 39.3, 4, and 6, there are no changes. However, Rule 39.5 says that the attachment will remain, it will remain under attachment pending the outcome of an interpleader or unless it is sooner released from attachment upon order of court. And then it says sub-rules 41, 14, 17, and 18 shall apply with the appropriate changes. Now, if you go to your rule books, ladies and gentlemen, and if I give you 2 hours, I guarantee you're not going to find Rule 41, 14, 17, and 18. These are part of the amended rule, which we will discuss later. But coming back to Rule 39.5, it says that will remain under attachment pending the outcome of an interpleader or unless sooner released from the attachment upon a court order. So this makes sense. The attachment, if we have an attachment, if there's an interpleader, the 4 months do not apply because it's pending. And I think the sale would also have this effect. The sale is also pending, of course, if there is no claim in that regard. We now come to substitution of Rule 41 of the rules. There are new rules, 41.1. This, where I spoke earlier, ladies and gentlemen, when I mentioned there is an alignment, there's a move to align the High Court rules and the Match Court rules. This is that alignment in terms of this amendment. Rule 41.1. The execution creditor may issue out 1 or more warrants of execution. Previously, he was allowed 1. If you look at Rule 45.1 of the High Court rules, this rule is almost the same. So this is an alignment now to the High Court rules. Rule 41.2a. This is very, very important, ladies and gentlemen, and I hope we haven't made this mistake between the time this rules came, the amendments came into effect and now. No process of execution shall be issued for the recovery of any costs awarded by the court by any party, until such costs have been taxed by a taxing master or agreed in writing by the party liable for the payment of such costs in a fixed sum. So that cost that appears on your warrant of execution that's not yet taxed. Ladies and gentlemen, you cannot claim that money from the debtor. Now here we come to a question where when we were discussing this, the question of ethics came into play. So the scenario is such that the deputy or the sheriff goes out, we demand payments, and the debtor says, okay, I want to pay. How much must I pay? How do you calculate it now? Do you take those untaxed costs into consideration as well? I leave that to you to answer. Rule 41, 2B1. It says untaxed costs may be included in a warrant of execution. It may be included, but I want you to look at 2. So here's the scenario. We went out, we demanded payment, payment wasn't made, we attached goods, we got instructions, goods were removed, brought to the stores. The whole process took place. We sold the goods. Now we're busy with the distribution account. And the attorney says, okay, here you are. These are my costs. Please include it in your distribution account, in your plan of distribution. The rule says, if costs are subsequently taxed, it may be included in the sheriff's distribution account if the original bill of costs has been duly allocated and lodged with the sheriff before the date of sale. Before the date of sale, ladies and gentlemen. So previously, we know the attorney used to send us these costs. Here we are, you've got sufficient money, you pay it over. The rule now says he has to give you tax costs before the date of sale. Do you see the important change that has come in here? Thank you. Are there any questions before we proceed? Mr. Burton?
Mr. Dawood.
Yes, sir.
Tarnay wants to know, she says, good morning, Mr. Dawood. For clarity purposes, can a sheriff only request security when there is a third-party claim? Based on experience, most sheriffs request security prior to proceeding with the removal.
Thank you for that. I think the rule is clear. The old rule says when the sheriff is in doubt. The new rule says when there is a claim. So the rule says you may not ask for that now, or you may only ask if there is a claim. So you would go through the whole process of attaching and removing, well, attaching, not too sure how far you would go when the claim would come. The claim usually comes after the attachment in most cases, but we do get those that come 2 minutes before the sale. So the rule is quite clear that if there is
just in short, if you can maybe just explain how our insurers work in terms of Rule 38 and why we request prior to the removal.
The insurers, like I mentioned earlier, the insurers require us to get the indemnity before, so to keep ourselves covered, failing which, of course, our up and we'd be contrary to their rules and regulations. But like I mentioned earlier at the beginning, is that we are in discussions with the insurers right now. And the insurers have mentioned that there's case law which is contrary to these rules, but we are still waiting for that to come to the fore. And when that does come, it will be given to the board for sheriffs, etc., to look at these, and then obviously if there are changes, this would be made known to the profession as well. Thank you. May I proceed, Mr. Burton?
Thank you, sir.
Thank you. Right, moving right along, ladies and gentlemen, we now come to amendments to Rule 41.3. Basically, it's the process in which you would go and you would attach goods. So the rule reads, when the court order or the order of court or the warrant in this case is given to the sheriff would proceed to the residence, the place of employment, or business. This is very important. Unless the execution creditor or the instructing attorney gives different instructions regarding the location of the assets. This is the old Rule 41.1a. Now, ladies and gentlemen, this one here, this is the rule I've read out to you. So basically what it means is the warrant says the address is number 4 3rd Street. But the attorney now tells you on his covering letter that the assets are actually at number 17 4th Street. So the rule says that they may give you that instructions. So unless you would proceed to the address on the warrant, unless the execution creditor or the instructing attorney gives you different instructions regarding the location of the assets. Obviously, it would have to be within your jurisdiction as well. We would then go to the place where we would meet the debtor, whoever's present in the house, as we normally would do, and there we would demand satisfaction of the warrant. The rule says demand satisfaction. Obviously, meaning we would ask for payment. This is the warrant. This is what we require. Do you have it? We would demand that so much movable or disposable property be pointed out as the sheriff may deem sufficient to satisfy the warrant. And if the defendant, whoever we are busy questioning, fails to point this out, we would then search for such property. You notice it's not much different from how we would normally do it, but the wording in the rules have changed. Are there any questions? Can I proceed?
There is one question.
Thank you.
A question from Andy. I think they're actually instructing 10 to please refer to Rule 38 to A and subsection 2. So it was an answer. It's not a question, sorry.
Okay, now that's fine. I may continue. Thank you. Ladies and gentlemen, we're still busy with this rules of Rule 41. As I mentioned earlier to you, that the changes are not only in terms of the rules, but the way the rules have been numbered. Now, this is very important. If we know that when sending out the return, that the rules are at the bottom of the return as well. So you've executed the warrant in terms of Rule 41. What your systems that you are using, most of the systems that we are using, we've not changed the rules. The rules haven't changed. The sub-rules haven't changed. So, excuse me, when you print out the return, when you compile the return, automatically it's when we give you a rule number. Those rules have changed. Those rule numbers have changed. So this is very important. Again, it's in the government gazette. So let's see what they look like. Rule 41(1)(b), where there's an endorsement on the warrant, endorsement of the warrant when we receive payment. We're all aware that the only document that may be endorsed is a warrant of execution. So here we have the old rule, 41(1)(b). The new rule, ladies and gentlemen, the number is 41(4). The rule remains the same. The rule number has changed. Rule 41(1)(b). You may notice that I've changed I've put it in a chronological order in terms of the new rules, which would make it easier for you when going through this piece here. If the asset is insufficient that you've asked the attorney, you've asked the debtor to point out the assets are insufficient, the attachment will still be made. The new rule, 41(5). If the debtor does not point out, the sheriff will make an inventory. That is the old rule 41(1)(c). The new rule is 41(6). 41(2). The rule says the sheriff may open any door by force, may open any furniture. Now, 41(7), the same rule, but in terms of 41(7), the words "or make use of a locksmith" has been included in there. The old rule 41(3), sheriff must exhibit the original warrant, etc., is now 41(8). I see your hand, Pakama.
Okay, Mr. Dawood, Tani would like to have some clarity that what happens when the sheriff is already attached and removed, and it is okay. They just removed it.
Okay. See how good I am with answering questions, Ms. Pakama. Okay. Okay. May I continue?
Thank you.
Okay. Thank you. So 41(3), where the sheriff will exhibit the original warrant, the new rule is 41(8). Rule 41(5) of the old rule, the sheriff will sign and leave a copy of the inventory. The new rule is 41(9), and it states in the format that corresponds substantially with Form 33. All the forms that we're referring to, ladies and gentlemen, if you have the entire government gazette with you, all the forms are at the back of it. But Form 33 is, I know most of the colleagues that I know are using this. It's the same form that we use where we have the conditions at the back of the form. And then we got 41(10). 41(10), there's basically just a cosmetic change on there. Doesn't affect the essence of the rule. 41(4) of the old rule, requirements complied by the sheriff, judicially attached, etc. This now, Rule 41(11), ladies and gentlemen, when I spoke about the alignment with the High Court rules, if you look at Rule 46(13), one of the sub rules there, it says that when we complete the plan of distribution, it must lay with the registrar of the High Court. Now look at this. This is something now which again is one of those gray areas. We understand what it means in theory. In practice, this is going to be a problem. Rule 41(11) says the sheriff will file with the clerk or the registrar any process with a return, what the sheriff has done thereof, and furnish a copy of such return and inventory to the party who caused such process to be issued. So what does this mean? It means once you've completed your attachment, you, not the attorney. Previously, we gave the return to the attorney, it was filed, changed. It says the sheriff will file with the clerk of the registrar any process. So you will have to go to the court that has issued that document, and you will file what you have done. So your return in your inventory must be filed with the clerk of the registrar of court. So in theory, we understand what needs to be done. here's the problem in practice now. So the document was issued, Gauteng Sheriffs, the document was issued from maybe from Cape Town or somewhere. Or do you understand the problem that might arise out of this here? Mr. Mlando, I see your hand.
Sorry, I carried on talking without unmuting.
That's fine.
There's still a concern with the same question that it was just referred to answered questions, but the button is still not happy. It's specifically asking for clarity. It says, what happens when the sheriff has already attached the removed the goods, and at this stage is presented with a claim? Will they have to release the goods to avoid storage costs, or is there a timeline as to when the claim must be presented?
There is no timeline when the claim can come 2 minutes before the auction also. There is no specific rule as to when the claim must be made. Once the claim is made, the interpleader process then starts, and that has its own set of rules. So if I understand the question correctly, so the goods have been removed already. What happens now that the goods are removed? Well, when goods are removed, there's a claim that comes in. The rule says that the attorney now has to give you your security. If he doesn't give you the security, you then, the rule says that attachment is suspended until he does so. And if he doesn't do so, then it lapses after 4 months. Then you would release the goods. That is my interpretation of it. There may be different interpretations. Like I said, you're most welcome to put it in the question and we can take it from there. I'm not sure if I've answered that question completely for the question. Mr. Mlando?
No response from them now, so I'll revert back to you if there's any more question on it.
All right. May I proceed then?
Yes, sir. Thank you.
Thank you. So, ladies and gentlemen, so 4111, this is the big change this is a big amendment to the rules. So, all those of you who've made attachments between the 1st of February and this morning, you will have to go and file with the clerk of the court all of those questions. Mr. Mlando? Mr. Mlando, I see your hand. I don't hear you.
Sorry, it says what happens when the court is far from your service area?
Yeah, that's exactly the gray area. That's what we're talking about. So in theory, we understand it, but the question is, how do you do it in practice? So this is one of those areas where we need clarity on, and we're trying to get those answers. Okay, moving right along then. Okay, here we're dealing with perishable goods, ladies and gentlemen. We're talking of the old rule is Rule 41.9. When the scenario is such, we go to a supermarket, we go and attach, we remove the goods, and there are perishable goods there. So previously, we would then have to go to court, not to court, but get consent from the magistrate to have an expedited sale. That rule has now changed. The rule is now changed to Rule 41.12. And Rule 41.12 now states that you require consent now from the judgment debtor, from the defendant. I leave that to sink in for a few seconds, from the judgment debtor, or you require indemnity from the execution creditor, plaintiff, against any claims for an expedited sale. So here the rule says you can go ahead, you can ask the judgment debtor, you can go to the defendant after you've removed all his goods, and you had this little battle with him, and now you tell him, I need permission, can I sell those goods, please? And well, good luck with that. And then, of course, alternatively, you can ask for an indemnity from the execution creditor against any claims for an expedited sale. Okay. Rule 41.6, here it basically says they've specified what the word specie means. So it's the Latin word for money. When money is removed, sometimes you go to a same supermarket, there's cash that's attached and removed as well. it's put into, it's sealed in whatever way you want to seal it, and kept safe and becomes part of the distribution account as well. Rule 41.7a deals with instructions to remove. That rule is now, the new rule is 41.14a. Basically, the attorney would give you instructions to remove the goods, or if not, a premises sale, but basically deals with instructions to go out and remove the goods. Then 41.7b deals with immediate removals. Ladies and gentlemen, this is not the burden. The burden of this request does not fall on the sheriff. The burden to get permission to have the goods removed immediately is with the instructing attorney. So the instructing attorney must satisfy the clerk in writing of the desirability for the immediate removal of the goods attached, either upon issue of the warrant or at any time. The registrar will endorse the document containing the instruction and authorize the sheriff, or under authorization under paragraph B. So how does this work? You know, when you get your warrant, you don't have to do anything up. If the goods have to be removed immediately, you can't take that instruction on the instructing letter. You can't take it on that only. It has to be endorsed by the clerk of the court on the document itself. At the back, normally, if on the second page or wherever, it would say endorsed for an immediate removal. It is either signed and stamped out there at that point, and there is another stamp, of course, where from the clerk where the document has been issued. So don't look at only the one. It has to be endorsed for an immediate removal. But you don't have to satisfy the clerk. You don't have to satisfy the clerk. This burden lies with the instructing attorney. Mr. Mlando, I see your hand.
Okay, I have a question. A question from Mr. Mkomisi. He states that this is technical. The wording itself is questionable. Will is not a must. For practical purposes, the word will is an option, especially if the court that issued is far, or is he wrong?
No, he is correct. I agree with him there. That is what the rule says. So again, it is one of those rules where we are taking it up with the rules board. But Mr. Mkomisi is 100% correct with that. Thank you. May I proceed?
Yes, sir, you may.
Thank you. Okay, rule 40, old rule 41.7b says where there's the absence of any instructions to remove the goods, the sheriff will leave it on the premises where it was attached. Now we come to the new rule 41.15a, and Mr. Mkomisi, here the words again are very important. Any person whose movable property has been attached by the sheriff may, together with some other person, sorry, there's just a little typing error there, may, together with some other person of sufficient means, who binds himself or herself as surety to the satisfaction of the sheriff, undertake in writing to produce such property on the date of appointment for the sale thereof, whereupon the sheriff shall leave the said property on the premises where it was found. Ladies and gentlemen, in my opinion, this is a risk to the sheriff. This is my opinion. I would not do this. What this is saying is that if a person of sufficient means, we need to find what is the legal definition of sufficient means, now binds himself as surety and says, leave the goods here, I will produce it on the day of sale. I will bring it to your premises when you have the sale. Okay, this, in my opinion, I wouldn't do. It's a risk to me. It would be a risk. What if the goods are not there? Then the deed of surety is in terms of Form 37A. If you want to go ahead and allow someone to say, let me sign the document, leave the goods with me, and I will bring it to you. Okay, moving along. Rule 41.7a, the new rule is 41.16a. So if the previous rule, 15a, where we were going to get surety where the goods was going to be left and the person would bring it, if that is not applied, or the execution or the execution creditor direct otherwise. The sheriff will remove the goods to a convenient place of security or keep possession thereof on the premises where they were attached. The cost of removal and storage may be recovered from the sale and execution. This is straightforward. So if you get instructions to go ahead and remove the goods are removed, taken to a place of security, a convenient place of security, or kept in possession. In practice, we know we all take it to the storeroom there. Okay, and the cost for removal and storage may be recovered from the sale and execution. This is mentioned in the rule as well. Rule 41.7c of the old rule says, of course, whatever instructions is given will be done without avoidable delay. The new rule is 41.17a. Again, ladies and gentlemen, why I mentioned the new rule, you'll notice the change in the rule numbers. When you're giving an attorney a return of service, when you've compiled a return of service and you're giving it to the attorney, it's going to court. And if you're using the old rule, it's not going to make sense. I think it could be challenged. 41.7b, this is usually the conditions that we put at the back of our notices of attachment, where the defendant, the goods that are attached may not be used, may not be let out, may not be lent. And of course, many of you ask the question, this is just going slightly off the topic now. We get this phone call sometimes from colleagues and say, look, we went to go and remove the goods. The goods were not on the premises, and the attorney wants to lay a charge. In terms of what? Now, this is very important. I had a matter maybe last week, I think, where we went to go and remove a motor vehicle. The motor vehicle wasn't in terms of a warrant of execution. And the defendant went and laid a charge at the police station for motor vehicle theft. He laid the charge stating that the vehicle had been stolen. Now, there's a massive difference between Section 107(2) of the Magistrates Court Act and the theft of a motor vehicle. Okay, so we have to correct this thing. If you look at 107(2), it basically outlines actions where, like for example, if the motor vehicle is stolen, can the charge be laid? It must be laid under that section, etc., and lays out all of those rules there. So there's a big difference between a motor vehicle being stolen and hidden away from the sheriff. So that was corrected. And if they ask, it's in terms of Section 107(2), ladies and gentlemen. That question is asked quite often. I'm sure most of you know that already. Mr. Mlando, I see your hand.
Okay, I don't know if I'm going to actually say it as he meant it, but he says, what happens if it's a landlord hypothek? The attached goods are left on the premises. Is that in order?
Again, the instruction here is, now whose goods is it? Does the landlord want us to leave it on the premises where it's attached? Yes, the rule allows us to do that. It can be left on the premises. But of course, it's under his instructions. So when we go back and the goods are not there, it's obviously it's at his risk. I hope that answers the question.
I hope so too, sir. But he will give us more clarity if he's not happy.
No problem. 41.17b, that's the new rule. Now, ladies and gentlemen, just I need your input here. The rule says, and shall deliver such profit or increase to the sheriff. This is an addition to the rule. I'm not too sure how would an asset that has been attached increase in value. I mean, if I've attached a motor vehicle, if I've attached a Toyota, for example, and I value that Toyota at 40,000 rand, when I go and remove the motor vehicle, to me, it's still valued at 40,000. So I don't understand. Perhaps somebody can enlighten us on this here. What do they mean by and shall deliver such profit or increase to the sheriff? I'm assuming that the asset that is attached has accrued value. So if it's a gold bar that I've attached, obviously the gold bar is worth that amount of money. But I'm going to sell it. It's still, to me, it's still the same value that I have. increased in value in regards to the market value. So I'm not 100% sure on that. Mr. Mlando, I see your hand again.
Okay, the question is, should the proceeds not be enough to cover the judgment debt, nor the storage fees of the sheriff, then who should be liable for the storage fees?
Then the attorney, your instructing attorney, is then liable for the shortfall on the sales. Thank you.
One,
Yes, Mlando, Mr. Mlando.
the increase is like when the cow had a calf.
Yes, that I also assumed at one point that was the situation, but I was later told by our rural sheriffs. I'm also a rural sheriff, but I was told by our rural sheriff that when you attach the cow and the cow is pregnant, you basically attach the calf and the cow together, and usually we don't separate the calf from the cow. So I think that could be an answer, but again, this is open to interpretation here. Mr. Mlando, I see your hand again.
No, that was it, sir. Oh,
Thank
sorry.
you very much. Yes,
Sorry.
yes, please.
It says, could the increase be livestock, animal? Oh, it's the same scenario.
Yeah, so it
Yeah.
could be. I'm not saying it's not. It could be that, but maybe somewhere we'll find the correct answer. I'm sure we will. Thank you very much. Rule 41(7)(e). Sorry.
No, I'm sorted. Thank you.
Thank you. Moving right along. Rule 41(7)(e), old rules. If the custodian is in default, he is not entitled to recover any remuneration. That rule, the rule exists. It just changed to Rule 41(17)(c), and the word other than the judgment debtor has been included in there. Rule 41(7)(f)(1), attachment lasts for 4 months. The new rule is 41(18)(a). It still lasts for 4 months, ladies and gentlemen, unless a sale in execution is pending. Unless the sale in execution is pending. So that is now, obviously, we know that. So we've attached the goods. We're going to sell it now. And you asked to give a sale date on the 3rd month of the removal, and you give a sale date after the 4 months, it doesn't lapse because the sale in execution is pending. If I may continue. Is the old rule 41(7)(f)(2) says if an order in terms of the ex parte application is made, there's no confirmation required. There is no change to these rules here. They just the rule numbers change. Rule 41. I see some hands that are raised. May I ask, please, Mr. Franklin, I think it's yours. If you could put your comment or your question in the Q&A box, please. Thank you, sir. Rule 41(8)(a) speaks about how you dispose of the assets that have been attached. It's sold, obviously, publicly for cash by the sheriff. The new rule is 41(19)(a)(1). It says it will be sold to the highest bidder in terms of Rule 41(17)(a)(2) with provisions of Rule 43(10) and shall supply with appropriate changes to the sale and execution of move property under this rule. Ladies and gentlemen, this one basically speaks about how you're going to sell your goods. So it will be sold to the highest bidder, etc. So there's no change. There's no fundamental change. The sense of it is still the same. We go to Rule 41(8)(b). It's the same. The sheriff will, in conjunction with the attorney, we will prepare sale notices, and those sale notices must be affixed at the court or any building that is used as a court as close as possible, or as close as possible to the place where the goods are being sold. The rule is the same in the new rule. This is very important, ladies and gentlemen. Before I continue, are there any questions at this point here, Mr. Mlando? Yes, ma'am. Mr. Mlando, I can't hear you.
Sorry, I thought I had unmute myself.
That's fine.
It says that please can we go to rule 4118C? I see we're still on 418A. We're still proceeding to 4118C, or are we done with it?
Okay,
And then
can I,
John
sorry,
says
what was that, Mr. Mlando? Sorry, 41?
4118C.
See, okay, all right. And what was the next one?
And then Joanne says, when is a sale pending?
Okay, a sale is pending after you give the sale date. The sale then becomes pending. So using the example I gave just now, we've removed the goods 3 months ago. If there's 1 month left in terms of the attachment, the attorney now asks for a sale date. So obviously the sale date is given for some reason after the time it would expire, that it would lapse. So it is pending. It doesn't lapse after 4 months. It is then only after the sale. So it's pending until the sale is there, even though it's after the 4 months of the attachment life that it has.
Okay, there's another one. Can a judgment
Yeah.
debtor participate in an auction of his or her movable, immovable goods?
You know, that is a question that's asked quite often. I personally don't see any reason why he can't participate. As long as he has the money to pay for the goods that has been removed, that he's buying. So I don't see, personally, I don't see a need. I'm not aware if there is any rule that prohibits him from participating in the sale. Maybe our colleagues would enlighten us that there are such rules. Thank you. The question on Rule 4118C, sorry, we're going to come back to that just now. Yes, Ms. Mlando?
I suggest that the sale is pending when all the requirements of the sale is met, and such sale notice is done and in place.
Correct. Correct. That is correct as well. Yes, I agree with that. Okay. Thank you.
That's all we have for now. Thank you, sir.
Okay. Thank you. All right. Ladies and gentlemen, very important Rule 41.8c. I've mentioned the number 5,000. When I mention the number 5,000, I think something comes to mind. Assets that are attached, goods that are attached, right? To the value, this is the old rule, from 5,000 and above. That sale has to be advertised in terms of Rule 41.8c. The rule has now changed, ladies and gentlemen. The rule says an amount equivalent to the monetary jurisdiction of the small claims court, currently 20,000 rand, the sheriff shall indicate and direct the execution creditor to publish the notice of sale in a local or other newspaper circulating in the district. So the rule has changed, the amount has changed. Previously, we know when the goods, they attach asset to our the deputies go out, we make an inventory, the goods are valued at 5,500 rand, anything above 5,000 rand, we know that the attorney would advertise that particular sale when it was going to happen. He would advertise the sale when it was supposed to take place. This has now changed. The amount has changed. The amount is now linked to the small claims court jurisdiction, monetary jurisdiction. Currently, that is 20,000 rand. 20,000 rand. That can change. I'm saying currently because it's changed, I think, 3 times in the last few years. So it's 20,000 rand. So the sale will only be advertised if the value of the goods that are attached is 20,000 rand and above. Now this affects our businesses, right? I'll explain to you maybe a suggestion as to how we can soften that impact. We look at D again. The sheriff may post the sale notice on his website upon instruction from the execution creditor. However, he must still affix the sale notice and include in that in the sale notices his own website details. Now, ladies and gentlemen, we know from a practice point of view, our sales are better when the sale is advertised. You have more people attending the sale. We know that. Now the rule here says that it has to be 20,000 and above. Now I know the smaller officers, many of the officers we don't get goods to the value of 20,000 rand, or if we do, it's very rare. But so how do you now attract customers? Look, you may post it on your own website. That is in terms of the rules. But it doesn't stop you, ladies and gentlemen, from advertising yourself. You can advertise. You can advertise the sale in execution. But be very, very important, be aware of the copy. For example, you can advertise on Facebook. But what you can't advertise on Facebook is obviously the parties, the case number, the defendant's name, plaintiff's name, etc. Copy Act restricts you from doing that. You can advertise on Facebook, social media. You can advertise. There's nothing stopping you from advertising yourself. The only change is that the requirement for the attorney, the monetary amount changes from 5,000 to 20,000 rand. Ms. Mlando, I see your hand.
Okay, we have here from Ms. Lamini. Says there are instances where the sheriff does not remove the assets and opts to conduct the premises auctions due to the size and the volume of such assets. Hope this is still acceptable if the instructing attorney is informed accordingly.
Yes, the rule says that if there's no instructions to remove, the attorney can tell you, leave the goods on the premises and sell it from there. The rule doesn't change. There's no change to that rule. So that's still, you can go and sell it on, there can be premises sale. I hope that answers that question. Okay.
Thank you, sir.
Thank you. Moving right along, ladies and gentlemen. Rule 41.9 says the sale cannot be less than 15 days after the attachment. The rule remains in terms of rule for the new rule 41.20, it remains the same. 41.21. Now, all of this that I'm going to discuss with you now is basically, I'll explain the first one to you and you will understand when we go along. 41.21, where the property is subject to the real right of any third person is to be sold in execution. Such sale must be subject to the rights of the third person unless he or she otherwise waives such rights. So what does this mean, ladies and gentlemen? This means that if you are selling something where there is a right of a third person in there, the right of the third person must be protected. So how do you protect the third person's right or any other person? They must be notified of the sale. They must be made aware of what is going on. And there are other ways of doing that as well. Ms. Mlando, I see your hand again.
Tanya says that they received a query from a person who says that someone was served on another person, and they want to find out if that was not in contravention of the Popeye Act.
Yeah, it could be in contravention, but it wasn't. I don't think it was done deliberately. I'm not going to spend too much time. I'll be very honest with you. I am aware of the basics of the Popeye Act. I don't know everything, but I don't think it was in I don't think it was done deliberately. So I don't know. We have our attorneys sitting here with us, our attorneys who are sheriffs as well. Maybe privately they can provide assistance to the person who's asked that question. Thank you. I apologize. I'm not too familiar with the Popeye Act. Okay. Moving right along, ladies and gentlemen. Rule 41.
One last question.
Sorry. Yes, Ms. Mlando. Yes.
Does the attorney require permission for the magistrate, from the magistrate, for the sheriff to conduct the sale on site?
No. There's no rule that says that you require permission from the magistrate. You can have the sale anywhere in your jurisdiction. There is no rule that says if it's going to be held on the premises, you require permission. The old rule, the only rule where you required consent, in terms of the old rule, was when you sold perishable items. In terms of the new rules, you don't even require consent from the magistrate for that now. So no, you don't need consent from the magistrate. Okay. Ms. Mlando, any more questions?
we open to comments on the part of the Popeye Act. You can even add them on the chat if anybody has something to breathe on that effect. Thank you.
Thank you very much. Rule 4110, the sale is stopped if sufficient funds are raised. Of course, this is the old rule. Rule 4122 is the same. Rule 4211, if there's a surplus after the sale. Now, ladies and gentlemen, I'm going to take you back to the previous slide. Remember, now when we talk about surplus after the sale, we know that previously, or in terms of the old rules, now you would get all the costs from the attorney now, and you would now say, he owes me this, he owes me that. So that money would be paid over. Remember, you can only pay over taxed costs, not untaxed costs. And that tax cost, the original bill of costs, must reach you before the sale, not before you draw up your distribution account. Okay, this is just to remind you what we spoke about earlier. Rule 4111A of the old rule says if there's a surplus after the sale, that it must obviously be paid back to the debtor if it can be found. If it can't be found, then the rule says it must pay the balance into court. And if it's not claimed from the court after 3 years, then it must be paid into the National Revenue Fund. Now we know that we don't pay it into court anymore, nor do we pay it into the National Revenue Fund. I'm going to say something now. This is not a rule. This is what is being practiced now, is that when there's surplus funds, it's paid over to the board. I'm not going to speak any more about that because I know I'm going to see a million hands going up now asking questions about that. What I'm saying is in practice, when we received our legal obligations, we are asked what surplus funds we have, unclaimed residue, as is known to us. And that is usually paid over to the board of sheriffs. Okay, the National Revenue Fund, as far as I know, I don't think exists anymore as well. But this is what the rule says. Ms. Mlandu, I see a question.
It says, this is Johan. My opinion, service of process regulated by the Magistrate Court Act, Popeye Act, cannot overrule. So I think he says that we can't allow the Popeye Act to overrule the Magistrate Court Act.
I agree with that. I mean, we've got our rules of service as well. But I think the question that was asked initially was, it was served on the wrong person. Obviously, we need more details on that. Was it served at the wrong address? Was it served? So we need more information to answer that. But I agree with what everyone said.
But in that particular instance, it was just straightforward. It was served on another person.
Yeah, on another person. The rules allow us to serve on another person. I mean, the rule 9 allows us to serve in different ways. And it allows us, like I said, we don't know the whole background to it, but I'm not going to go into that now. After this, we can have that discussion. It's fine. Thank you very much.
And then one last one. How do we determine the order of preference in the distribution process? Okay,
that is easy. I've referred to it already in my previous slides. The preference creditor gets the first payment, and then I'm going to refer that. I'm just gonna get back to you on that question. I don't have it with me right now, but it's one of my previous slides. Basically, I think there's a rule. I will find it just now. But it's the preference creditor is paid, and then it follows in terms of the Insolvency Act who is next in line to receive payment. So there is a rule to that. I mentioned it earlier. I'll come back to it just now. I will go back to that one. I'll make a note of that question.
Thank you very much.
Okay. Rule 42.1, if incorporeal property is available for attachment, this may be attached without prior application to court. Ladies and gentlemen, we are all aware of what incorporeal property is. For example, shares. So incorporeal meaning something that is intangible. Shares in the property, a right title and interest. This is what we're talking about here, as opposed to attaching a lounge suite, for example, which can be touched and felt. Excuse me. And this is what we're talking about here, incorporeal attachments, but I'm sure you're all well aware of that. Okay, so we can attach it without approaching court for an application to attach the incorporeal property. The old rules, 42A, 42.1a, the old rule was 42.1. If there's an attachment of a lease, a bill, a promissory note, a bond, or other security for payment of money, this will only be completed when, now this will make sense to you. It's only completed when notice is given by the sheriff to the lessor, the lessee, the mortgagor, mortgagee, or person liable. If you remember when we spoke earlier, we mentioned if there are third parties involved, that we need to notify, their rights have to be protected as well. This is an example. Then we got, so it's only completed when notice has been given to all the parties that are concerned. The sheriff shall take possession of the documents, if any, evidencing the lease, etc. Or if he can't find the documents evidencing this, then he has to certify that he has been unable to locate such after a diligent search. So if he can't find the document, it doesn't mean that the attachment is incomplete. He has to certify that he's been unable to locate such. And number 3, in the case of a registered lease or any registered right, notice must be given to the registrar of deeds. So again here, I think when we talk of a registered lease, anything over 99 years would have to be registered with the registrar of deeds. (42.2), which the old rule says, where movable property is sought to be attached in the interest of the execution debtor in property pledged. The new rule is 42B1. Instead of movable property, the word is now used where the incorporeal right in the movable property sought is in the interest of the judgment debtor in the property pledged, leased, or sold by a third person. The attachment is only complete when all parties are served, where you make an inventory of the said inventory and evaluation of the said interest. And in the case of an attachment of incorporeal property, of all incorporeal rights, only complete when a notice of attachment is given in writing to all interested parties, whether right to all interested parties, whether right is an immovable asset, the registrar of deeds must be notified. Again, BB, the document evidencing ownership must be in the possession of the sheriff or certified that he's unable to locate the same, and then he makes an inventory and evaluation. Again, I don't know if you noticed the trend. Ladies and gentlemen, it's very, very simple. All parties must be notified of the events, of all the events. They must be notified. And that's the important thing here. I'm almost at the end of my presentation, ladies and gentlemen. We now come to the attachment of property which is subject to a lien. And again, it's the same as we've done before. All parties involved must be notified. The same rule applies. Documents must be sought. If it can't be found, it must be certified that we can't find such documents. The method of attachment, in terms of section, this is the rule that on the government gazette as well. In terms of the method of attachment, in terms of section 32 of the Act, where the attachment of property in attachment of property in terms of rent shall remain the same as that of in execution. So it remains, the rule remains the same, the rule hasn't changed. The method, etc., remains the same. Mr. Mlando, any questions so far?
Nothing from my side yet, sir.
Thank you. That concludes my presentation for today, ladies and gentlemen. I want to thank you all for your attendance and the time. I hope it's been beneficial. I know there are many, many questions that are in the back of your mind now. Please feel free. You can ask the training committee of the board. You can contact us. I think many of you know me. You're more than welcome. If I don't have the answers, we'll make an effort to find the answers for you. But I want to thank you for attending. I see Ms. Mlando, you have your hand up again.
Okay, so I just wanted to remind you with regards to that preference of a distribution, the order you said you were going to answer that. And then there was that 4118,
C.
I'm not, yes.
4118C.
Yes.
All right, let me see if I can find those quickly.
And let me just see. There's something that just came from Andy right now.
Okay,
Just
I'll take that in a second, Ms. Mlando. Let me just find this one quickly.
no problem.
Andy knows all the answers already, Ms. Mlando. So we can ask
Maybe
Andy to answer
coming
this
with
one.
an answer now.
Yes, maybe. What is that, Ms. Mlando, from Andy?
Just some information. Sheriffs must be drawn to Rule 4116B. This will impact on our CCMA matters and small claims matters, simply meaning that the attorney and the CCMA will not pay for removals and storage costs when there is a sale pending. Deputies will now be required to attach much more assets to cover costs. And then it says, in terms of Rule 4119C, the costs of advert will have to be covered from the sale in the CCMA matters and the small claims matters. And then from Joanne, we have a suggestion. Suggest future training in attachments of a lease bill of exchange, promissory note, lease, and so on. And then
Noted. That I think is very important.
Yes, and then Nicola says, have attachment in place. Okay, I think they got cut off. They were still trying to get the rest. Okay, here it is at the bottom. Can an allabone be rendered if an attachment is made of insufficient assets without those assets being sold in execution?
That's a very interesting question regarding the nulla bona. Nulla bona means that there's no asset. It doesn't mean there is no sufficient assets. So I don't think that would apply, but let's leave that open to our colleagues as well, to our attorney colleagues to answer here as well, please. But I'm coming back to the question on the preference creditors.
Yes.
To the person who asked that question, it's in terms of Rule 39(2)(a), in order of preference referred to in Rules 43(14)(c). So if you go to Rule 43(14)(c) of the Magistrates Court rules, it will give you an outline of what is the preference, how would you pay, how you would pay this out. Obviously, the first person would be preference creditors, but then you've got to determine the legal status of the preference creditors. And then there are other creditors, and this all follows as per the Insolvency Act. So, but this is explained in terms of Rule 43(14)(c). Okay. Mr. Nando, what was the next question? 4118.
Yes.
I think
14.
you asked. Okay.
Yes.
Let's see if I can find that one quickly. (4118), you said.
Yes, 18C.
Okay, let's see if we can find it. Okay, so what was the question in terms of this 4118C, Ms. Mlando? The rule basically, if I may just go on here, the rule basically says 4118C, in the event of a claimant lodging an interpleader claim with the sheriff in accordance with Rule 44, the period of 4 months referred to in paragraph A shall be suspended from the date on which the claimant delivers his or her affidavit to the sheriff until the final adjudication of the interpleader claim, including any review or appeal in respect of such interpleader. So I hope that would answer the question. So basically, if there's an interpleader, then the time period is suspended until the outcome of the interpleader. I hope that answers that question. Mr. Mlando, are there any other questions? I sorry, and I take note of what Andy has, sorry, I take note of what Andy has said, and I agree with him. Those points are very relevant, and we should be aware of all of that as well. Thank you, Andy.
Okay, we have a remark from Mr. Rantesh, and he just wants to thank the board for the session. And then Andy would also has another one. He says that the assets that are attached need to be sold first, and if there is an insufficient further movables to be attached, then a nulla bone can be rendered. The attorney will use sheriff's plan of distribution and all movable assets that were sold. That is his view. So which means we have to exhaust all the assets before we can actually say that we are rendering a nulla bone.
Agreed. I agree with that as well.
For now, okay. And then again, he says that point in 4118C is that the delay stops counting when the affidavit is received and not interpleader issued.
Yes, the rule now says when the affidavit is received. So I agree with Andy there as well, not when the interpleader proceeding starts.
Okay.
All right. Thank you, ladies and gentlemen. That concludes my presentation for today. I want to thank you for your attendance. I hope it's been beneficial. I apologize for my shortcomings. Like I said, I didn't draw up these rules. I'm merely interpreting it with a team from the Board for Sheriffs and some of our other colleagues. If we have misinterpreted any of the rules.
Mr. Dawood,
yes,
before you close completely, sorry, I don't want to close out Siabonga. He's asked that we clarify 4111 and Gundlovu is concerned regarding the removal and storage costs to be claimed after the sale can be a problem. If we're doing a sale for an individual person, not the attorney, should they not be able to make payment on the shortfall? I personally think the rule needs more attention.
Okay, so obviously here, if you are selling it for what I consider an office service, let's say small claims or something like that, then yes, you would give, in practice, this is what I do, I would give a quotation to the plaintiff and tell him, look, this is what I estimate the sale to be. These are going to, this is my storage cost. So all this is done before the sale. So the plaintiff is aware, or the applicant is aware, that this is exactly how much we're going to charge. This is what we expect, and then we can take it. If we can ask for a deposit as well to cover that. So if you do everything before the sale, you plan everything, you would know your storage before the sale. You would know how much you're going to be charging. So you've got all those figures. Give that to the plaintiff and tell him, look, this is what it's going to cost you. I go one step back. When I get instructions to remove, before I remove, after the attachment already, I calculate if I'm going to remove, this is how much I'm going to charge. And if I get all of these, this is exactly how much storage I'm going to charge. So I give all that information before I even go and remove. I give all of that information to the applicant, to the plaintiff. I tell him this is what it's going to cost you. And there's absolutely no guarantee we're going to recover these costs in the sale and execution. So he's well aware of all of these things. I know many of us have been reported to the Board for Sheriffs where we've done this and there's no money coming to the plaintiff and we've cheated and we've robbed, we've taken all the money. So to avoid all of that, I do that in advance. And in that way, I avoid the problem of looking for money after the sale and execution. Thank you. Ms.
There's
Mlanda?
just a request that you please show the slide for Rule 42.
Which one in 42, ma'am?
I think they're just trying to take note. They're not specific. They just said Rule 42.
Okay. Which one in 42? There's quite a few in 42.
Okay.
42 starts here.
I think we should just leave it on the screen for sometimes once we are
Okay.
concluded.
I'm not sure if this whole thing is being recorded, and I'm not sure if the slide is going to be made available on the board's website. I'm not sure on that yet, but yes, no problem. If anybody wants the slides, we can email it out as well. It's not a problem. So you can just give that information in the chat box there. We'll be able to email the slides if that's going to help you in any way.
Thank you so much, sir. Then there's a lot of people that are expressing gratitude for the session. We appreciate them too. Thank you so much.
Thank you. Thank you very much. It can only work if we all do it together, and I appreciate your attendance as well today, and I appreciate the time that you sacrificed here today. I saw Mr. Burton's hand up a few minutes ago. Mr. Burton.
Thank you, Mr. Dawood. I just wanted to go back to a question posed by Precious when she inquired about the CCMA providing indemnities to the value of 5,000 Rand to sheriffs, as they offer, because sheriffs request unlimited indemnity. Just to Precious, I think I've got a copy of the indemnity that our local CCMA officers use, and she's correct. They do mention an amount of 5,000 Rand, but that 5,000 Rand is directed to the applicant or the execution creditor. It's the middle paragraph of the indemnity that is important for the sheriff, because it says the CCMA hereby indemnifies the sheriff of whatever against any claim and of any nature. So I know why she's referring to the 5,000, because the 5,000 is the last paragraph of the indemnity currently used by the CCMA, but that last paragraph is directed to the applicant or the execution creditor, where the center paragraph of the indemnity is addressed to the sheriff. If possible, I will send this to Bernadine or Lucinda. I will email them a copy of the indemnity that is currently being used by the CCMA from Benoni and Johannesburg, so that they can then post it, if possible, with your slideshow on the board's website for ease of reference. Thank you, sir.
Thank you very much, Mr. Burton. Ladies and gentlemen, once again, thank you very much for attending. This concludes my presentation. We're not done yet. I want to thank you for your attendance. I hope it's been beneficial, and my personal vote of thanks to the training committee, all the ladies in the background there, Bernadine, Lucinda, Candace, all the other ladies who are busy pushing and pulling the right buttons there. Thank you so much for making the magic happen. It's been a privilege working with all of you. And Mr. Burton, I think we've taken note of the comments that there should be more training in terms of attachments of incorporeal and things of that nature. I think, Mr. Burton, we've noted that as well. And once again, ladies and gentlemen, thank you so much for your attendance. And now I'd like to hand you over to the Deputy Chairperson of the Board, Mrs. Amanda Titus. Thank you very much, to everybody. Mrs. Titus, over to you.
Good morning, everyone. Firstly, I would like...
I'm in a meeting, can you...
Sorry, can everybody hear me?
Yes, we can, sir.
Okay. Good morning, everyone. Firstly, I would like to tender an apology on behalf of Mr. Mark Morgan, the Chairperson of the South African Board for Sheriffs. And then also with the apology, we also would like to congratulate Mr. Morgan for being elected as the Vice President for the UAHJ. It's the African Union of Judicial Officers. So it's well done to Mr. Morgan and to our profession. It's just for the better of all of us. Then secondly, on behalf of the South African Board for Sheriffs and the Training Committee, I would like to thank all the key role players and participants in this morning's session. I hope it was very fruitful and informative to everyone. And as Mr. Dawood mentioned, there was requests for many more sessions like this. Mr. Burton and us on the training committee will definitely look forward to have more of these sessions to the profession. And then also, last but not least, I just want to encourage each and everyone to complete your evaluation forms, because if your evaluation form is completed, the officers will be able to get, they will issue you with an attendance certificate. Once again, thanks very much. Have a lovely day further and a lovely weekend to everyone. Thank you.